Jacob, you tell me when we're set to go, and we will get underway.
We are rolling.
All right. Good evening, everyone. Jim Santel once again here. Thank you for being with us here in Waukesha, and again, appreciating the work of Blue Sky Waukesha, including Kristen, the board of directors, everyone else. As always, we have an opportunity tonight, a high-quality group. If you have questions, comments along the way, get my attention, and we can take those up as we are proceeding through our discussion tonight. We do have, as always, lots and lots of things to talk about, and we will get through most, if not all of that. The good news, of course, is this is the second of six, count them, six classes altogether, and we'll make good use of the time tonight and in those future situations as well. So, there we go. Let me go back here again. So what we're going to do tonight, we're going to initially do a couple of things coming out of the Supreme Court just today because they are very important, but here is our very ambitious agenda today. We're going to finish up on some First Amendment issues we began to talk about last time. The one thing we did not talk about was religious liberty, and we'll chat a little bit about that, including a recent Supreme Court case. We're going to go into the Second Amendment, and yes, tonight's going to be a little bit grisly, but I thought it's important not only because of the guns cases coming out of the Supreme Court, but also because the Second Amendment obviously is there, and a lot of focus on it, not only based upon things that happen in America, many of the violent shootings, but also because of the way the Supreme Court is handling that. And so I'm going to spend a little bit of time tonight talking about what that right is, what it is not, and where it comes from historically. Then, believe it or not, we're going to, this looks as if we're jumping over a couple of things, and we are. We're going to talk about the Fourth Amendment, also some current events having to do with searches and seizures, which I suspect you will also find interesting based upon recent news. And yes, jumping over to the Eighth Amendment then, which is all about cruel and unusual punishment, and in particular the death penalty. Also the subject of a lot of focus by our judiciary. And as if that's not enough, we're going to begin, perhaps, more likely next time, to get into issues related to the Fifth, Sixth, Ninth, and 10th Amendments. You may note from the syllabus that Kristen distributed that in our third class, we're going to be spending a lot of time talking about the interaction between the states and the federal government, federalism, this thing called the Constitution, this thing called the Federalist Papers. How does that work? And it morphs very, very nicely from our talk about the first 10 amendments into that subject matter. So catch your breath and let us go into this. As Kristen said, we're going to start with a couple of things that happened today. They may not fall very neatly into some of the amendments to the Constitution, but they're very important. And again, as we talk routinely, this is on a day when issues like the decision by the Supreme Court signing with a manufacturer of the weed killer Roundup that overturned a jury award from a Missouri man who claimed that he was using the herbicide causing cancer. Supreme Court, a major decision there. We're not even going to talk about that one. Under any other circumstances, that would be huge. For what it's worth, the DA in New York has also indicated just late today that they're not going to pursue yet a fourth trial of Harvey Weinstein for rape charges there. He is plainly facing a lot of other time in other jurisdictions. Those kinds of news items on any other day of the week, any other time in America would be things we'd be talking about. Tonight, we're going to be chatting again about First Amendment, Second Amendment issues, and others, but getting initially to these issues related to the other big Supreme Court cases that were issued just this morning, 4 of them altogether. Right now, they're down to somewhere between 10 and 12 decisions yet to issue, and we'll get at the very end of our time together this evening, we'll talk about what those are, what we can anticipate probably for next week, right before the 4th of July holiday. But there were, in fact, 2 major immigration cases. Let's talk about what those are all about. One of them has to do, obviously, with this thing called temporary protected status. And as the slide indicates there, focusing principally, although not exclusively, on the status and the deportation, the potential deportation of some 350,000 Haitians, about 6,100 Syrians, and likely to have implications for others, but a dozen other countries out there. So the impact of what the Supreme Court has done is not to be overstated as well. It is dramatic. And again, the TPS program itself, as the slide indicates, this program which provides some safe haven for people who are coming here. Why? Because of war, natural disaster. When we think, regrettably, about Haiti recently and the atrocities that have been suffered there, Syria, similar kinds of things, a program, again, that provides some safe haven. And there's no doubt that the Department of Justice and Homeland Security and the administration generally in recent months has said this is a program that we would like to get rid of as a part of the president's overall immigration policy enforcement. It has been the subject of a lot of public discussion out there whether TPS should continue, a lot of advocacy on behalf of people who are not residents, formal residents of the United States. They're here, but certainly not citizens of the United States, but people nonetheless. And it's always been the tradition of our country, again, to look to these kinds of programs to provide them with some safety and security in crisis situations. The takeaway tonight, one of two major cases. The case is Mullen versus Doe, 6-3 majority. Yes, indeed, right down partisan lines, political lines, if you will, once again, including some very dramatic dissents here from the three who are, again, very much opposed to the decision by the majority here, finding that the president's inclination and his plan to get rid of this program is, in fact, supportable and supported. Associate Justice Samuel Alito writes there, the federal law, which again this TPS is a part of, created by Congress, by the way. Again, another congressional enactment, the president going in the opposite direction, prohibits the courts, he said, from second-guessing what the administration wants to do, even though this program is in place. And he looks at it and he says the text is clear, nobody should be confused about this, and its plain meaning is very broad, meaning the president has this great prerogative to do what he wants to underneath that. That is one of two major decisions today. Immigration, undeniably, at the White House, already some excitement over the decision by the Supreme Court to uphold the president's immigration policy in that area. So that's TPS. Much related to it, and again, this could be the subject easily of an hour discussion among us, TPS, and then we also have basic asylum issues. And this has to do a little bit more with geography and when one appears in the United States of America. It has long been the practice of the administrations of the past to say that if you are seeking asylum, and again, sounds very similar to TPS, again, for things that prompt you to leave your country of origin, typically for persecution. You are concerned about the safety and security of your family, and you have decided that the only way to ensure your livelihood in the future is to leave, and you're seeking quite literally what the asylum word is all about, which is, again, another place to live and grow and develop. And the issue has always been, under the policies of the past administrations, both Republican and Democratic, that if you come to this country and you cross the border, you can, in fact, make an application there. You're making an application for asylum to stay here. That is not an easy thing to do. Plainly, you have to establish, as you do with the TPS program as well, that you're entitled to it. But the geography here is important, and we've always permitted those people seeking asylum to come to this side of the border and make those applications here. There has been a policy, again, in recent times, and you can see that it's gone back and forth, frankly, also involving the Obama administration, Biden administration, the first and second terms of Donald Trump, going back and forth about what the Border Patrol folks and what the people at the border, how they're going to handle those people who are showing up and asking for asylum. Again, traditionally, the answer has been, all right, you can come into the United States. We'll monitor your application. This is not plainly a granting of asylum, but we'll let you do it here. And once you are here, then that process can go forward. The practice then, called the turn-back policy, and again, variously in place and not in place again recently, has been that you've got the government officials, law enforcement basically, at the border saying, we're not even going to let you in, therefore your application cannot be pursued, basically providing a wall, if you will, quite literally an administrative wall against those people who would be seeking asylum. Much related, once again, to the TPS, but a different kind of program. Here again, we have the same result from the United States Supreme Court, saying that the decision and the way in which the government has been operating and keeping those applicants on that side of the border is not unconstitutional, it is permissible, and again, a part of the administration's policies in these areas. Huge decisions, obviously, because they impact not only large numbers of people, but also, as much of the reporting, there are articles coming out already today talking about the huge impact. I'm reading one here, plunging many migrants into limbo, nowhere to go as a result of this. Talking about 1.3 million people from a dozen countries, all sorts of concerns here, stories about people who have been here and who are seeking asylum or under the TPS program, huge numbers of people, and also a lot of the commentary coming out about the impact of these Supreme Court decisions on our place in the world, on the face of the planet, and what we have done in the past, if not completely to welcome everyone, at least give them an opportunity. That plainly, with the Supreme Court's decisions today, changed dramatically, and there you have it. We do have on both sides of these cases, again, the three of them, speaking in very strong language about the impact of what this is all about. Sonia Sotomayor speaking on behalf of the others on her side of the aisle, that should say the decision to slam the door shut on all who are fleeing persecution. This is a system enacted by the Congress, she says, to help people who need our assistance, and we are shutting that down today. More language in the dissent on both of these cases to that same end. Again, very significant decisions coming out of the Supreme Court. And again, at the end of our time together today, we'll tell you about what is still left as we go ahead into what will eventually become the 4th of July weekend next week. Questions or comments about any of that? Again, the opinions themselves are quite lengthy and quite complicated. Please go ahead, and I'll repeat the question.
For this one, does this go retroactive, or is it just for people coming now?
It is effectively retroactive because you have all of these people who are, again, waiting for the decision, waiting to make their applications on that side of the border. The sense is, again, when you're talking about hundreds of thousands of people, probably in all categories. The question was retroactive or not, who does this affect? And there have to be people sort of on both sides, but the big impact is people waiting for a long period of time. It is not just proactive, and we're not giving any grandfathering effectively to those people who might already be here. And it's always been, that has been the criticism of the program from the start, that at a minimum you've got people in process or want to be in process, and you are saying, we will not even let you start down this road. Good question. Kristen. Mm-hmm. Yes, right, absolutely.
Each president could have a different rule, and then this could go back and forth with different presidents, right?
Absolutely. Kristen's question is, can this go back and forth between presidencies? And the answer is absolutely yes. Joe Biden was a very big advocate of the TPS program and went very public on that. You can have a president who, again, will reinstitute it. The name of it is less important than what it does, right? And so you can recast it as you want, and regrettably, there will be, again, continuing issues not only in Haiti and Syria, but other places around the world. And those programs can continue to be supported by a future president who wants to do this. Virtually all of this, although the structures of it are set by the United States Congress, that's why you have Sam Alito in some ways saying, well, the language is clear, I can't do much about it. There is a great deal of discretion, and you also see that in both of these opinions. Whether you agree with it or not, the Supreme Court saying inside these structures, we still give this executive a huge amount of authority with respect to immigration. Ask yourself, as you look through the constitutions that Blue Sky Waukesha has given to you in the past, or that you've got, whether it's with you tonight or will go back home, ask yourself again whether this was really the intent of the Congress. I will go on my soapbox a little bit, following up on Kristen's good question, to say, wouldn't you feel a whole lot better if it was the United States Congress who was articulating precisely what the immigration policy should be? We know that during the course of the last campaign, there was omnibus immigration legislation afoot, It was garnering support from both Democrats and Republicans. We know what happened. A presidential candidate said, do not go forward with this. A lot of these things would have been incorporated into that, and so there would have been clarity. And again, whether you like it or not, you wouldn't have had to have a Supreme Court, 9 people deciding. You would have had a policy decision by the people you elect and send to Congress. That's my continuing mantra. I know you hear that from me virtually every class, but it really does underscore the notion. Immigration, congressional issue, right? Not the president shouldn't be involved in it. Yes, responsible for executing it through Homeland Security, through the Department of Justice, but ultimately all these policy issues, once again, being decided by the Supreme Court. And I have gotten used to it. I'll offer with due respect to all of you, I think we've all gotten used to the Supreme Court making decisions. And that also is a good segue into what we're going to talk about next. Keep inventory even tonight about the ways in which the Supreme Court is telling us what our policies should be in ways that, at least in the past, I have not lived through 250 years, obviously, but we deferred a whole lot, and as I've said before, this thing, the Constitution, there's a reason why the very first article talks about the legislature in page after page after page. The executive branch, yes, executing what the legislature says, and oh, by the way, the judiciary, not really a footnote, but don't worry, they'll take care of things if there are disputes. That plainly is not what has happened after, again, many years under the Constitution. Please. Absolutely. You could, again, on all these cases, including those that we're going to talk about tonight, to the extent that there are truly constitutional things that the Supreme Court decides and they tell us what the Constitution means, that's different. But for example, to use something we chatted about a bit last time, the Voting Rights Act, which I still maintain is the single biggest decision coming out of the Supreme Court, regardless of what happens next week on presidential powers and transgender sports and other things that are out there. That issue that the Supreme Court finding that Section 2 of the Voting Rights Act really no longer has teeth. I think that's the single biggest opinion coming out from this term. With due respect to the hundreds of thousands, 1.3 million people, do not mean to undermine or minimize the significance of that. The point is that if the Congress wanted to overrule what the Supreme Court has done on that case, you pass legislation saying, let us be more clear about what we'd like to do. A lot of that is pending. It is called the John Lewis, you fill in the name of the year, the 2026, the Voting Rights Act of this year. It would affect and reverse what the Supreme Court has done in 3 different cases, including now most recently Calais. This is the same kind of thing. They're upset about this, and legislatively they can pass this. The concern, of course, is that on legislation, where does that go? Even if you get both houses of Congress, there's a person named the president who has to sign off on this. So you've got that issue as well. But you also have, if the Congress has got enough support on these things, you can do a legislative veto, right? That's very rare these days, but that's out there too. The Founding Fathers thought about all of these options. And the idea, once again, was to ensure that when it comes to these big ticket items, what we're doing with all these people, really the legislature should be the one defining it, and then we'll have the executive do the granularity, figure out who is at the border, who has to come and go. We're not asking Congress to make individual decisions. That's the execution. The big ticket items should be handled by the legislature. Great questions, everybody. Appreciate all that. And so let us get, again, a little beyond these huge issues, and we'll talk tonight, go back again to the First Amendment and finish up on religious liberty. Again, we talked last time about capacities, obviously, to petition government. Free speech is big, to protest. And the one that we did not talk about is sort of embedded right in there. It's often said the First Amendment is sort of the, if you think about it, that could be easily 6 or 7 amendments in and of itself, right? And you have to wonder, James Madison, were you just so excited about putting all this together that it dumped in here? This, as you know, as I mentioned last time, I won't repeat the history again, but for those of you who are new to the class this evening, the First Amendment was actually the 3rd one that James Madison proposed. He came up with 70 initially. The United States Senate said, no, way too many. They were looking at 72, eventually 12. And his First Amendment was never enacted. His Second Amendment became our 27th Amendment. Nonetheless, with all that math, if I've kept that right, our First Amendment does still say that Congress, meaning government, cannot do anything to abridge the freedom of speech and press and rights to peaceably assemble, petition government. But before that, those two very important lines: no law respecting an establishment of religion or prohibiting the free exercise thereof. And it's important to always, I know that all of you appreciate this, to understand that there are two different but much related concepts there, right? Establishment of religion, the idea is, contrary to what some leaders in our nation say these days, we do not have an established religion in America. And in fact, our Congress, our government says we're not going to establish any type of religion. That entire concept there, that alone could take up a huge amount of time. And you should know, I'll be very brief about this, that it used to be that when it comes to establishment of religion, the question was under something called the Lemon Test, not lemon cars, but it has to do with a particular Supreme Court case. The question was whether or not the entanglement between the government and religion was sufficiently upsetting to you. If government was somehow involved in religion or religion was involved in government, that you would say, kind of your gut test, it was more than that. Does this make you unsettled when it comes to the confluence of those two? What John Roberts and the recent court has done when it comes to establishment is erase much of that, and he has permitted, again, an awful lot of lack of clarity, and has substituted that Lemon Test with another test that basically says that if you are in any way discriminating against religion, then you can't do that. Well, you think about it, anytime you say, you know what, we cannot fund a religion through tax dollars, I'm discriminating against religion then, right? Because I'm not giving them monies that others would get. And so the rule that he has described almost swallows up the entire issue, and that is the reason why, with respect to establishment cases in particular, but also free exercise cases, which we'll talk about now, almost always, not completely, and we'll see an example tonight where it did not happen, but almost always those people who have been advocating that their faith, their religion tells them that this is right, and therefore they're asking for some special remedy from the government, they've almost always won. And this Supreme Court has been very, very accepting of and open to not only hearing cases, but also granting the relief that people who are advocating for faith and their religion would want to promote. That is not in any way to suggest that our faith communities, our religious communities in America are somehow in second status. The notion is that government should not be involved and that we should not somehow affect your ability to exercise faith in whatever way you want. And so the rules on this have changed a lot. Again, perhaps some other time. Again, as we meet, frankly, in the nave of a church, we should chat more about that. But tonight, I'm going to focus specifically on the free exercise issue. And it maybe is the one that's perhaps in some ways easier, but also more challenging to understand. The concept is, again, is just as I said, the idea, if you look at the legislative history behind this and the things that the first Congress said about this, the notion was we don't want to get involved in this. And if you have got a legitimate and even a religion that we may not recognize completely, we will let you to observe that in a way that your faith permits you to do that. We will not let you do that in a way that somehow erases the line, again, when it comes to establishment of religion. And so let's talk about what just happened a little bit in recent times. And you'll remember some of these cases. This is a very, very brief primer on religious exercise. Let's go back to 1963. This is one of the major cases. The Supreme Court, again, siding on behalf of a religious position here. You've got a state that was denying unemployment benefits for a religious person, Seventh-day Adventist, who is taking off work on her Sabbath, and the government saying we're therefore will not pay her. They found that, again, the state cannot do that, and because this was the exercise of her religion and did not want that, the government in any way to be impinging on that. Way back in 1963. I should mention once again, this is a real small summary, jumping ahead to 1990, and this is one that, again, you may recognize in particular because it had to do with a number of our Native American Indian tribes and their use of peyote with respect to a hallucinogenic substance, some of their religious aspects of their faith. You've got there either a sweat lodge or other things like that. And the Supreme Court said that there, because in the state of Oregon, the particular hallucinogenic drugs were illegal and they were subject to confiscation, you could be prosecuted for having them, the Supreme Court there says that even though it's a part of faith, basically the governmental rules prohibiting the use and the distribution of this particular drug, those supersede what the Native American tribes were doing there. And the question, and this has really been the standard, the question is whether or not the applicable laws when it comes to anything, regardless of faith, even if they incidentally burden a particular religious practice, as long as they're generally applicable across the board, we will support those. And so you may remember those kinds of cases. And here's the one that I suspect you all remember, and it really does underscore for you recently the problems with the way the Supreme Court has been handling free exercise cases. Look at the picture up there on the right side of your screen. That is an actual photograph that ended up, believe it or not, in the annals of the Supreme Court, because what you have, this is the Bremerton case, again, coming out of the Great Northwest. Remember this case? It's the football coach who brings together all the members of his football team after the Friday evening the game, public school, public setting. That happens to be the 50-yard line of the field there, and it is their practice to then get together. The coach leads them in a prayer, and plainly a Christian prayer in the school. Going back in other ways, again, establishment cases basically say that, yes, indeed, you can have Bibles and you can have Korans and other religious texts in school. You can't instruct from them in public schools, right? And so what happens here is this particular football coach brings all these folks together and they pray in a public setting, Christian prayer, very, very overtly. The Supreme Court, by Neil Gorsuch, describes this, and he says, don't worry, this was a very private, non-public event, and for that reason, they permit the coach to go ahead with this, even though, again, mentioned public schools. And Sonia Sotomayor, to her credit, she says, Neil, again, not quite that casual, of course, but she dissents, and she says, Neil, I'm attaching to my dissent a picture. You tell me how private that was. And an awful lot of people think she got the better of the argument there. But there again, you've got a Supreme Court that exalts recently the notion this is a public school, and we've got a public faith exercise, and that is permissible as late as, again, 4 years or so ago. Very significant. There's a question right here.
Yeah, so when it comes to actually instructing students,
Yes.
as opposed to, so there was a situation long ago, I want to say about 10 years ago.
Mm-hmm.
Oh, you know it?
I think I heard it. Please go ahead, yes, and I'll repeat the question, yeah.
A very, very well-known, well-respected, great teacher
Mm-hmm.
was reprimanded for teaching about Islam.
Right, right, right.
And so he had to go in front of the school board, and they said he was indoctrinating the students.
Right.
What is the difference between calling that public and instructing students? Oh,
Right.
by the way, he was a world history teacher.
Yep.
So it's based on his curriculum.
Exactly, and that's a very important part. The question, to the extent it didn't pick up on the mic, which is, again, another great question, what do you do? And I'll begin with this. I think it's implicit in your question. Can you teach world religions? Yes, you should be able to do that, right? You need to be able to say, yes, we're going to teach Christianity, but also Judaism and Islam. We're going to teach Sikhism, we're going to teach Hinduism, Buddhism, and you may not get to every religion on the face of the planet, but 5 or 6 major. Can you do that? Yes, there's nothing wrong with that, because there you are not, you're exactly the right word. You're not indoctrinating. You're not saying, open up the Quran, let's all pray together. You're not describing a prophet in a certain way that, again, would reveal an allegiance in a particular faith direction, but you can teach that. And so I don't remember the exact situation there, but certainly a teacher, again, in the category of teaching world history, faith history, that you can do. What the Supreme Court said, again, this goes to the establishment issue, is you cannot do this. This is the one, there are photographs of this from the 1950s and 60s, 40s. let's all open our Bibles up in the third period and let's read from the book of Leviticus, right? And we'll go around and then we'll pray afterwards. That's what you cannot do, because there you are doing what would approach indoctrination. Can a student in a classroom have a Quran or a Guru Granth Sahib from the Sikh tradition in his or her backpack and take it out and read it? Sure, absolutely. Private, individual, as long as you're not doing it perhaps in the middle of the biology class. It's going to interrupt things that are going on. Can you do that privately in a study hall and at lunch? Of course you can. But what you can't do is, again, that government-sanctioned, school-sanctioned instruction. And so if the teacher there, McGuanago, was saying, I would like you all to become members of the Islamic faith, and I'd like you to join me, and that would be problematic. The question, I think, there, which you know better than I, was he doing that, or was he simply exposing them to this notion that, okay, you may have grown up, especially in this part of the world, familiar with the Christian faith. There are 5 other major faiths out there, and this is one of them. And we want to tell you not only about that, but also, for what it's worth, I seem to recall this the more I think about it, the Islam and Judaism and Christianity are all Abrahamic faiths. And many times you can teach about that they all look to Abraham as the basis for their faith. All right, they're all connected, right? And even some of the other religions rely very dramatically. It's simply a matter of fact that Mary and Jesus show up in the Quran. They're there. Jesus identifies as a prophet. So all these different interactions, that's interesting things for students to know about, right? And so the question is, are you indoctrinating, are you teaching and encouraging, or are you simply instructing about what the world faiths are? Great question, please.
So referring to this case.
Yes, the football coach, right?
Talking about, how did the Supreme Court
Justify, right?
justify that was not
Yeah.
indoctrination?
Yeah. I'm going to encourage you, and we can do this afterwards. I don't have it right in front of me. It's worth it to read a few paragraphs from what Neil Gorsuch wrote. And again, Sonia Sotomayor is not wrong when she says you have the way, my own view of this, a little bit based upon my own assessment of this, to which you may disagree if you read them. The only way I think that you can explain that away is to describe it as Neil Gorsuch has, which is your eyes are not telling you what's really going on here. If this had been, for example, maybe you get together afterwards in the coach's home, he invites somebody over and says, you're not obliged to be here, I want you to tell mom and dad you're coming over and we're going to pray at some point. It's not public, it's not happening there, it's gotten under the sanction. You're not all wearing the school's uniforms, you're not part of the school. Then you can probably do this. Sonia Sotomayor says, this is not that. This is exactly all the problems with both establishment and free exercise. Your question, I think, answers your question itself. It's pretty difficult to justify it.
And when I look at that, considering that those are
15-year-olds, right?
15, 16, 17-year-olds,
Yep.
it appears to me that there might even be coercion.
Right, and that's,
involved in that.
and an awful lot of the argument when this case came up was just that, precisely talking about the reason why we have all these principles. You've got young people, right, 14, 15, 16, 17, maybe 18 years old, and there were some amicus briefs filed, others who are arguing in the public domain that, again, I was there, I suspect all of us who were in sports or other activities in school, when you're 15 years old and 25 of your companions are doing something, as long as it's not jumping off a bridge or doing other things that are illegal, and everyone says, let's go together and let's all do this thing, and oh, by the way, the coach wants us to do this. You can call it coercion, you can call it compulsion. You're simply not going to say, I'm going to be the one person in this photograph that's going to be published now for all time who's going to be standing over here because I know what the Constitution says about freedom of expression and establishment of religion. That point, the fact that you've got these very young people, was not lost on the critics of this decision either. Very good point. Good. So they've got a little bit of that. And then this happened just last year. We talked about this in one of the classes last year. This comes out of Baltimore. And this was the case in which the Supreme Court said that if you, I think you may recall that I sort of had my hair on fire last year about this one in particular, again, because of the mixing of faith and public schools. A public school, Baltimore Public Schools, largest school district in Maryland, and the question is whether or not parents can opt out. Again, it's now a verb apparently, can get their children out of particular instruction, in particular if there are books that are describing same-sex marriage, LGBT issues. Can a parent get their child out of that instruction, again, if it's a part of an overall curriculum adopted by the school board and endorsed again by the educators there? Supreme Court says that the individual focus, the parents' understanding that having my child exposed to and reading this is so contrary to my faith that I can, in fact, in a public school, take my son or daughter, take them out of that class. And again, Alito writes that opinion because there's a real threat, as he says, of undermining the religious beliefs and practices of that family, of those students. The answer, which again the dissenters say, is that's fine. You can go to what's called a private religious school. And there, obviously, you can pursue this in whatever way you like. Again, the point of all of this is we've got kind of a mixed bag over time, and today I would offer to you, as you'll see in just a moment or so, that the issue of, again, First Amendment, freedom of expression, freedom of religious exercise, and especially, again, we're not talking about it a whole lot, but especially this issue of establishment is cloudy at best. And when you look at this fellow, for example, who is not Christian, he is Rastafarian. And his name is Damon Lander. He is in jail, not prison, but he's serving a 6-month term for possession of a small amount of drugs. And what happens when he is transferred from one facility to another is that the jailers quite literally put him in a chair, hold him down, and they shave off his dreadlocks. He is a Rastafarian. Remember this case? Some of you are nodding your heads, right? And it is a legitimate religion. Again, you can explore it at your leisure. And he maintains that by doing that, what you have done is you violated his rights to express his faith as he feels he should be able to do it. For what it's worth, at the time that this happens, because he knows that this may be a problem, he's got a court order from a judge there that says do not shave his dreadlocks. This is a part of his religious faith. Apparently, his jailers say, actually the allegation in the materials before the Supreme Court say that the jailers took that piece of paper, threw it in the trash, and shaved his dreadlocks, okay? He comes forward and he says that's a violation of my right to exercise my faith, and he gets some support, obviously, along the way. And what happens he files this under something called the Religious Land Use and Institutionalized Persons Act. Somebody in Congress had to get a better acronym for all this, but that's the statute. And it's important because the Supreme Court, in the end, makes the decision based less on the particular invocation of the First Amendment free exercise right, and more based upon the fact that under that statute, as they say, and this is Neil Gorsuch writing this again, there are limits to what you can do. And he says in particular, that is Gorsuch, on behalf of the court, a 6-3 majority, right down that partisan or political line, if you will, that perspective line. He says that because Mr. Landor is suing the individuals who did this, as opposed to the institution, the state itself, this particular statute does not give you that ability to do that, and therefore Landor is out of luck and tells him that he cannot go forward. We've got the three others who are saying basically, you've got to be kidding me, the Congress, again, by virtue of establishing this particular law, envisioned that you would be able to support the religious liberties of people in prisons and in other circumstances. And this distinction that you're drawing, this happens just last week, by the way, this is a last week opinion, this distinction that you're drawing between the state and the individual actors is not one that we should really embrace. Ketanji Brown Jackson saying, Congress has long used its spending powers to hold people accountable. And that's what we're trying to do here, beyond the direct recipients, which is the state, as opposed to the particular actors here. And so here we have, this is the latest version, again, 6-3, coming out of the Supreme Court, First Amendment, religious exercise, freedom of exercise of your faith, and basically telling Mr. Landor that he cannot go ahead with his lawsuit as he has described it. A great mix here, and again, this is not the last of them. Along with guns cases, which we're going to see next, the Supreme Court, I think by virtue of what the Chief Justice often says, is fascinated by religious cases, have to believe that there will be a whole lot more in the next term, both establishment cases and exercise cases. This is their latest statement on all of this. How do you justify this? How do you reconcile them? You work on that and come back next time and you can explain it to me and we can all understand how this all works together. So that's again, that's kind of our summary, if you will, of the First Amendment cases. Other questions? Yes, please.
Have there been any cases of a non-Christian religion? Like that coercion with
Yeah.
the football team?
Right.
Because I wonder how that would be.
Right. And again, you look at, this is Mr. Landor, he's appearing, that's actually the Supreme Court behind him. That's not just, they've got some veiling in front of her, they used to. And you can see his, for what it's worth, his dreadlocks at the time that this happened used to be down to his knees. He was growing them for decades, okay? So this is a hugely invasive thing to have happen. Plainly, he is not, we would not regard him as a Christian. He is, right? So you've got this particular
But I was thinking the other one with a coach.
yes, right?
Coercing a whole group of
Right.
young people. If there was a
Not that I am aware that we have got, for example, a Jewish school, right, or a Hindu or Buddhist school or an Islamic school. I do not know, and again, one of the great criticisms, candidly, you may or may not want to accept this as you look at these cases, especially in the establishment area, is that the Supreme Court tends to decide in favor of the faith group, of the religious group, and when it comes to money, scholarships, even construction, Supreme Court is always taking cases involving people of the Christian faith. Even this one last week, if you look at some of the literature, looking at him and saying, you did not get the kind of reception. He does go forward and he says, I'm very disappointed, but I will live on, I will do something more. That distinction or that point you're making about the nature of the faith, the underlying faith, it's one that should be taken a look at, right? And it's the reason for a lot of criticism of the Supreme Court when it comes to both establishment and exercise cases. And we'll see what they do down the road. The great majority of them have been Christian faith cases. So we've talked already, again, about immigration and religion, and so let's talk about guns, because we haven't been controversial enough tonight, right? And I'm going to spend a little bit of time on this, and I myself, with my own background, having done a lot of criminal prosecutions involving firearms and people who should not have them, who get them. Let's talk about the Second Amendment. I'm going to do a little bit of history of where this comes from, and I'm especially animated to do this because, as you know, gun violence in America continues to be a major issue, and there are times, even as late as the last couple of months, when I've seen people say things like, I have a Second Amendment right to own and possess and use a weapon. And the answer is yes, you do, but as you'll see, it's not unconditional. It is conditioned on many, many things. And so when you hear about, regrettably, what will certainly be the next mass shooting, they happen every single week in America, and we've got those people who talk about the importance of guns, as does one of our Supreme Court justices just earlier today. When we talk about these things, understand where this comes from. There's the Second Amendment. Of all of them, it's the one that, again, the English teachers among you, diagram this sentence for James Madison, right? A well-regulated militia being necessary for the security of a free state, semicolon, the right of the people to keep and bear arms shall not be infringed. That's what he wrote, okay? We'd clean that up and probably add 15 more sentences to it today. But the question is, what did they mean by that initially? And I'm going to offer to you a view based upon some exploration of my own and other people who have looked at what this meant at the time that James Madison put it together, again, passed by the First Congress of the United States of America. And so let's talk about James Madison. Recall once again that at the time, the firearms, I found that picture. This is the Battle of Bunker Hill, muskets, and they did not know plainly about things like AR-15s and Glocks and ghost guns and all those kinds of things that we think should animate this discussion today. But the notion back then, 1789, was that they were just coming off of the Revolutionary War, right? And although this is interesting history, I think, for many people, not you know this already, but to learn, they were very concerned about the notion that the government would have a standing army. And they were very concerned about not only the king coming back with his standing army, but we don't want to create what the king created here. And so what we're doing is we're going to say, if in fact we're invaded, if we've got some domestic violence here, we've got some other insurrection type activity internal to our nation, rather than having an army, what we're going to ensure is that, yes, you've got a right to hold your musket, your pistol, if you will, but the purpose of that is so that you can put together, again, a situation where you can respond not with a standing army, but rather a strong militia. And you'd come forward in the moment and say, okay, the community will all come together. That was kind of the concept here. Very concerned about very powerful government at the time, creating an army. That's not what they wanted. And they wanted to be able to, from the community level, defend against when the Brits come back, which they did, and other domestic unrest, wanted to be able to handle that on their own, and for that reason establish and that's what the language of this says, the right to bear arms shall not be denied. Also comes from the time period, of course, when the country is still growing. There's hunting going on, personal protection, some of the physical, practical challenges of the growth of the nation into those areas, including eventually what becomes Wisconsin and other places. So an entirely different view about the reason for that. And when you look at some of James Madison's writings on this and others, pretty much borne out by that. And again, we didn't spend a lot of time on this, if you will, even though we've had, obviously, gun sales throughout our history, the development of firearms. The reality is that this notion that now we have, since June 26th of 2008, for the first time since then in American history, this was the first time ever in our nation's history that we had an articulation by the Supreme Court of an individual right to ownership of a gun. And again, what you have here, that fellow, of course, is Antonin Scalia. He is no longer on the court, but he was a lion on the court, as you know, an icon in many ways. And he looks at all this history, and if you look at the Heller case, I'll tell you where it comes from in just a moment, he looks at all this, and he comes to a different conclusion than what I've just told you. And so if Antonin Scalia was here, he would say, Santel, you're completely wrong. For what it's worth, I may have mentioned this to you in the past, this is how old I am. Antonin Scalia was a professor of mine at the University of Chicago Law School, and so he did routinely say, Jim Santel, you're wrong about that, but in a completely different setting. He looks at all the history, and he says, no, James Madison, from the start, he acknowledges some of these other motivations, but he says, from the start, it was the Founding Fathers who said, yes, an individual personal liberty and the right to own a weapon, for what? For the purpose of defending your home, in your home, and self-defense. That may sound somewhat like what James Madison was articulating, but it really is a different concept, and this notion of having then a militia that kind of formulates, that's not what Antonin Scalia talks about. He talks about this being a very personal as opposed to a community interest, right? And so what happens is Dick Heller, he is in Washington, D.C., as you know well from recent times and past times. In the early 2000s, Washington, D.C. is a troubled place in terms of lots of violence, lots of murder, lots of crime, not exclusive to Washington, D.C. And what they do is they pass some legislation, and it's pretty dramatic. And it basically says if you're going to have a gun in our district, you've got to have it disassembled when it's at home, and all sorts of other restrictions that basically say that we need to stop the proliferation of guns in our district. And they do that because they want to stop people from being killed, all right? And so they do all this legislation. Dick Heller comes along. He is a resident there. And he says, wait a minute, that's in violation of my right to own a gun. How dare you, D.C. Council, tell me how to run my life, including possessing and using a weapon? And of course, initially, everyone says, no, that's very interesting, Dick, but that is a fringe theory. You're wrong about that. And for 200 years, your view of this has not been the one that has held sway. Supreme Court has previously said it's not an individual right that you have. It's what James Madison described. And what happens is Antonin Scalia comes along and he convinces a majority of the Supreme Court that Dick Keller is right, and that all of this history that has preceded 2008 has, for the most part, been an historical predicate that we have been misguided into believing, including people like me saying these kinds of things. And he says that the Second Amendment, there it is once again, the Second Amendment says that the right to keep and bear arms is personal, it shall not be infringed, and the reason that that's the case is that you can use it in your home, he says, for self-defensive purposes. That had never, ever been articulated before in all of our history. 2008, Antonin Scalia says it for the first time, changing the ways in which, and establishing, again, the basis for people today to say, I've got a personal individual right to own a weapon. That's where it comes from, Heller, okay? Significantly, I always say this. In Heller, Antonin Scalia, this very conservative jurist who changes the way that we think about guns in America in 2008, also goes on to say that just by virtue of the fact that I'm vesting in you a right to own a weapon in your home for defensive purposes does not mean that you can't impose conditions and restrictions and limitations on things like the development, the creation, the manufacture, the transfer, the use, the sale, the possession of weapons. All those kinds of things that we think about when it comes to reasonable, I would offer they're reasonable, rational limitations to keep us safe. Antonin Scalia said in Heller that those are okay. And so, for example, when you know about, and you've seen this both here in Wisconsin and other places, when you see people, and they've been successful in many other states, enforcing universal background checks, right? There is nothing inconsistent with universal background checks with Heller. Okay, just because you've got the right to own the weapon doesn't mean that you can use it under all circumstances and that you can get it without undergoing a background check. There are things called lethal violent protective orders, situations where if you see that Jim Santel, for example, is having a mental crisis of some kind and has a gun, and you're concerned about me, you're concerned about other people, under these particular kinds of legislation, you can go to a federal judge, a state court judge, and say, can you remove from Santel that weapon that he has during the time that he is plainly undergoing some individual crisis here? We'll give it back to him when he is through that, but right now he's a danger to himself and maybe to others. And if a judge makes that finding, you can, in fact, take that weapon. There is nothing unconstitutional about that. Things that mandate that weapons be maintained in the home in certain ways. All the kinds of things that legislatively are talked about here in Wisconsin and that are in place around the country, those are still permitted. Why? Because Antonin Scalia told us you can do them. Okay? And so that's the reason why legislatively all those things happen. So that's 2008. I'm skipping over a huge amount of history, which you'll be happy to know about. We get to 2022. Yes, please.
I understand Scalia said that, however, it's still, in my understanding, doesn't go to the broad perspective that people argue that they can own a gun. It's still, like, so for example, I go back to the original thing you said, Madison's not talking about that. He literally
Right.
said a well-regulated militia, period, that's at the end.
Right.
This guy ended up interpreting it different, which is wonderful about the law, you can interpret it any way you want. But that still uses strong limitation. So when people argue, I can own a gun because it's my right, that's not even remotely where we're at with the law.
That's right. And so the question was, again, great history there, as you've just described it. Is important to when someone comes up to you and says, I have an absolute right to own a gun, you do not. The absolute portion is the problem that's problematic. And yes, indeed, the Supreme Court has said this, all these other things can happen without violating what has now been acknowledged for the first time in 2008 as a right to own the weapon. You've heard me say this many, many times. Give me the right, I'll tell you what the condition is on it. There is no right in the Constitution, including all those things we talked about. First Amendment rights, it is without condition. Every single one of them has limitations on it. Why? Because we live in a society, right? And so your point is very well taken. And if you want to get into that debate with someone who says, I've got an absolute right to, that is simply wrong. And what you do is you say, go and take a look at what Antonin Scalia wrote in 2008. I sometimes advocate for the creation of some T-shirts or sweatshirts that say, give them Heller, okay? How creative of that, am I right? And quote this, right?
You want to donate to my campaign?
There you go, right? And again, it's somewhat tongue-in-cheek, but I'm quite serious about it, that, Heller says you can do just this, yeah. And those other kinds of restrictions have been supported. And then we get, as we're indicating here, we get to Clarence Thomas. And this one comes out of New York. We've got a similar situation in New York again, New York City, other places, Albany and other places in the state. You've got a situation where the legislature is very concerned about violence, gun violence in particular. And what they do is they say, you know what, when it comes to concealed carry, what we're going to require you to do, if you want to walk down in Central Park, if you want to walk around the Capitol in Albany, and you're carrying a weapon, concealed carry, you can do that, but you've got to be able to tell us the reason why you need it. And we're going to require you in New York to submit a form that says, you know what, I'm a healthcare provider. I need to get to work. I go through a particular neighborhood that is especially high in violence, and I may need to protect myself. Other situations where if you describe for the government the reason why you need to have this concealed carry and the weapon, we will grant you that right to do it. But if you cannot describe the reason why you need a gun on the streets of Manhattan, we probably are going to tell you no. Okay, you got to justify it, right? And so what happens is the New York State Rifle and Pistol Association, just like Mr. Heller, comes along and says, wait a minute, that is an unfair and inappropriate restriction on our right under Heller, under the Second Amendment, to hold weapons. And what happens here is it comes up to the Supreme Court, and that man, his name is Clarence Thomas, again, 6-3, different case, obviously, but he announces, obviously, under Heller, and then goes further, and he says two things, and this is why this case called Bruen, B-R-U-E-N, is so very important to understand. He goes on, and he says two things. One is, first of all, I'm expanding Heller. I am taking your right to own a weapon, and I'm expanding it to the public domain. Heller says, in your home, for self-defensive purposes. Bruen says you can do it out in public. You also have a constitutional right to carry a weapon in public. All right? Again, the question is, what are the circumstances under which you do that? And then he says that the only way that you can justify any restrictions on that right, hold on, is if you are able to look back in time, back in history, and look to some sort of historical tradition of firearm regulation. We've done this in the past in New York, in the United States, and we're simply doing more of it now. If you cannot look back to some history and say, yes, indeed, we previously required people to submit this form to justify having their pistol in their pocket, if you can't do that, then that regulation, that law will be stricken down. And I hope all of you are thinking, well, wait a minute, that Bruen test is almost impossible to meet, right? Because as we've said so often, if you go back, and in many ways, what Clarence Thomas and others are thinking about are once again that picture of Bunker Hill. At the time that James Madison wrote the Second Amendment, he didn't know anything about the kinds of weapons we have today. And if I say to him, or I said to him, or we discuss this today, and say, gee, what is the antecedent when James Madison is alive to a concealed weapon on the streets of Manhattan in the form, you would say, of course not. There's no antecedent. And therefore, under the Bruen test, if you can't find that historical predicate, your regulation, your restriction falls. And to your very good question before, there are an awful lot of people who looked at Bruen and said, haven't you just eaten up what Antonin Scalia said about all these conditions, right? Because if you haven't done these things in the past, We can't do them now, and therefore they're stricken. And so Bruin remains the law of the land today, but almost immediately it gets this huge pushback. And again, premised upon the notion, we've talked about this before, goes back to the larger issue of what kind of a constitution do we have? Is it a living constitution where we think about the fact that, yes, we've got AR-15s today, and we've got silencers and all kinds of things, or do we look back and say whatever they were doing back in 1789 without, again, lights of the sort that we have, automobiles, airplanes, trains, all these other things, if we've got to wed everything only to things that existed in the past, nothing will ever be regulated, right? And so Bruin gets a huge amount of pushback, and indeed you'll see here that under the Second Amendment, what happens is the Supreme Court, a little bit, it's not been abandoned, begins to recognize this was a really, really bad idea. And of course, at the time that Bruin is issued, a mere 4 years ago, the dissenters here are also responding very, very strongly and saying, this is unworkable. You cannot possibly have any conditions then if Clarence Thomas is right. So let's do some of those. And here's some indication, some positive thing in the midst of a, again, otherwise grisly discussion we're having here about Second Amendment issues. Meet Mr. Rahimi. Mr. Rahimi is a very violent person. That's not just my assessment, that's the assessment of everybody who's come in contact with him. He's got guns, and he is shooting them up when he is on the expressway. He's going into fast food restaurants and shooting up the fast food places when they don't respond to him quickly enough. And most importantly, again, as bad as all that is, he also has a partner. And he engages in what we today know as domestic violence. He is beating her, okay? And as you well imagine, at some point she says, I'm done with this relationship, and she goes into court, a state court, and she gets a domestic violence restraining order against him and wants the judge, and he does in fact say, yes, indeed, you stay away, Mr. Rahimi, you stay away from the petitioner here. Because he's got that domestic violence restraining order, there is a federal law that I used to enforce when I was an assistant U.S. attorney that says if a court has said that you need to stay away from somebody because you're so dangerous, there's a domestic violence restraining order against you, you cannot hold a weapon. Okay? That is one of the conditions, right? And it's in the federal law, and you prosecute people if indeed, among other categories, for example, if you're a felon, you cannot possess a weapon. All kinds of restrictions consistent with what Antonin Scalia said. Mr. Rahimi comes along. He's probably the worst case that those folks who are advocating for gun rights could possibly come up with. And what happens is he said, I should be able to get a gun, even though I've got this restraining order and I've got all this other violent activity in my past. You'll be pleased to know that 8 members of the Supreme Court, there was one, but 8 members of the Supreme Court who looked at Mr. Rahimi and said, no, we're not giving you a gun. And they basically say that, well, when it comes to Bruin, yeah, we know that James Madison, with due respect to him, really had no concept of the idea of domestic violence back in 1789. Those of you, again, who follow these things, and I know you all do, it's a relatively recent concept where we've criminalized the notion that partners can be responsible for, again, criminally responsible if you are beating a partner. That concept has not been around for hundreds of years. Supreme Court kind of does a linguistics, some gymnastics here, and they say, well, we've got some other close analogs, some matches here. We're going to keep Bruin in place, and we think that there are other statutes out there that are sufficiently close to this, and for that reason, domestic violence is one of those conditions and a restraining order that will prohibit you from having a weapon. It basically says that the Supreme Court is not completely beholden to gun interests. Of course, the one person, you guessed it, Clarence Thomas, who says, no, I think Mr. Rahimi should still have a gun. That is an affirmation, again, about the diminution of the Bruin test and the notion that, again, before the Supreme Court, when it comes to these kinds of things, they look at some of the practicalities of this and recognize more and more that this test is not a good idea. So we also get this situation from just last year. We talked about this, 2025. Again, what we have here is a situation, you can still go online today and you can order a ghost gun. You can order up the component pieces of a weapon, right? And so when you get that, you go to your living room, your kitchen table, and you put together the component pieces, and voila, you've got a gun. Whereas before you had the component pieces. You order the pieces, and then you put them together. The government comes along under the previous administrations, including Biden, and under the Gun Control Act, and says, when you are manufacturing these component pieces, manufacturers, you still have to abide by the federal gun laws. You have to put serial numbers on them. You've got to get licensed. All these other things that we do with real guns that are impacted or intact once they are purchased or gotten by you. The opposition to this says, no, that's not a gun. Because when it shows up, it's in component pieces, and it determines whether or not what the definition of firearms is. And believe it or not, the Supreme Court a year ago was fighting with people about whether or not this box of elemental pieces was a firearm. Again, 7-2 vote, but a majority basically says no. The fact is that you can assemble this. It's a sensible response to this. If you're assembling it and you are then putting together a gun, it is operable just like any other gun that you can purchase at a legitimate gun store. It's got to have the serial number, and everybody's got to comply with this. Once again, Vanderstock is the name of another case in which they, again, begin to withdraw from this history and tradition test of Bruin and are pretty practical in terms of what the Supreme Court would say about all of this. And then, then we're going the wrong direction here. And then we get to just last week and today. Meet Mr. Ali Hamani. There is also, again, 922G3. If you know that statute, I am really impressed because I always had to look it up whenever we used it. There are all kinds of restrictions, once again, on your ability to own a gun. One of them is, and I'm not going to do a real particularized description of this, but if, for example, you are a habitual drug user, such that it's changing your life. We're thinking about people who are using heroin and methamphetamine and cocaine, and it's affecting their lives. I think everybody here would say, probably, while you are a non-recovering addict of that sort, we probably don't want you to have a gun, right? And so that's what the law says. And if you go in and you purchase a weapon and you acknowledge that, in fact, you are a non-recovering drug addict of a serious nature, which is important here, you will not get a gun for that very reason. If you lie about it, you're in trouble. What happens here is Mr. Hamani runs afoul of the government in some other ways. There's a search warrant conducted at his home, and he's very cooperative, and he says, yes, indeed, I smoke marijuana on a fairly routine basis, maybe a few times a week. It's part of the record here. And oh, by the way, he says, I also have a gun right over there. I'll direct it to you that. And oh, by the way, in that cabinet, there is my stash of marijuana. He's very cooperative, tells him all of this. And the prosecutors come forward, the Department of Justice comes forward and says that because you are using marijuana habitually, you should not be possessing a weapon. And the question then is this the kind of person who we are targeting by virtue of having this particular statute in place? Supreme Court, you see, just last week, this is one of two major gun cases of just this term, says no. Mr. Hamani, under his circumstance, where he is using it probably, again, we can debate habitually or not, he is not the kind of person that we mean to prohibit owning a weapon. Neil Gorsuch, again, bends over backwards, again, like Antonin Scalia, to say, don't misunderstand us. You can still do an awful lot of things to prohibit people who are engaged in the regular and, frankly, very vigorous use of drugs. You can still prevent them. That's not Mr. Hamani. Neil Gorsuch says, we know drugs and guns are a dangerous mix. Yes, indeed, they can be, and we appreciate his saying that. He says, but, again, the government, here we go back to Bruin again, what the government says is we're justifying this based upon drunkard laws. That's what the Department of Justice comes up with, and the Supreme Court says, no, we don't like that analogy under Bruin, and for that reason, we're going to vacate Mr. Hamani's conviction under this statute. And it's important to note once again that although there are an awful lot of people out there who look at this and say, yes, a major victory for gun rights advocates. He gets his gun, as I look at it, it really doesn't change things. It has an impact, and obviously the headlines are such that gathering a lot of attention here. This is not, the Supreme Court is not saying that you cannot, once again, impose restrictions on gun ownership based upon habitual drug use. Gorsuch goes on to say, you can ban addicts or those previously intoxicated from possessing a firearm. You can does not prevent a prosecution when the drug deemed is so dangerous, methamphetamine, cocaine, other drugs, or if you've got a particular person whose use of those drugs is so vigorous that it causes you great concern. Proof that certain types of drugs always render users dangerous. You can still prosecute. It's not marijuana. It's not Mr. Himani under these fairly casual circumstances. That's last week, and just this morning we get yet another, and again, until a couple of hours ago, this was going to be just not yet decided. This one, again, very interesting in terms of what the Supreme Court does. You've got Hawaii and a couple of other states out there where you've got a law. You can see that basically in Hawaii has a very long-standing tradition, kind of Bruin-like, of having very strident gun restrictions. And so when it comes to concealed weapons and using those in places that are public but also private. So think, for example, about a gas station, a shopping mall, other places that are privately owned but where public comes onto the premises, okay? And the question is, can the public owner, can the private owner of that property prohibit someone from coming onto their property carrying a weapon? And it's a fascinating case, of course, because it pits basically the rights of private property ownership against guns, right? And so you may have people on the same side, different sides of the argument who have similar views on all this. Supreme Court this morning says that the Hawaii law has to fall. And once again, you get a member of the Supreme Court. Again, his name is Sam Alito, who says this, that the Hawaii law violates the constitutional right to keep and bear arms. He invokes Heller, and he says that what Hawaii does in basically prohibiting a private owner of property from keeping someone off their public access, carrying a weapon, that hobbles what the Second Amendment protects. He says it's the right of Americans to carry arms for self-defense as they go about their daily lives. That's what he wrote, published just this morning. And again, it is viewed as probably a win, if you will, for the gun community. The thing that I look at when I see this particular case is, again, this strong affirmation about guns in our society. Putting aside the particular aspects of this, yes, indeed, as I read this, and I think most people read this, you can still post, if you're a private property owner, you can still post one of those signs that says, you come onto my property, no guns, right? The question is whether or not someone who's carrying the weapon has to make an explicit request to come on, and the answer there is that kind of thing, getting permission to come on the property. That is what the Supreme Court says it would be forbidden by the Second Amendment. Doesn't prohibit someone preventing somebody to come on, but just by doing it very, very publicly. So again, a lot of things are going to be decided in the wake of this. The significant thing coming out of this, once again, is you've got the three other Supreme Court justices who are once again saying what you're doing here is you're protecting guns, not preserving any principle of law here. They go on. Hawaii has demonstrated a history and tradition of tight gun restrictions. What they're saying there is that's Bruin. You need some justification for this. Hawaii has had it for a long period of time, and majority, you're wrong. You're wrong to overturn the Hawaii law that says that you can only come onto property under these particular, getting explicit permission from property owners before carrying the weapon onto the property. Again, probably the kinds of things that will not change dramatically, but it shows once again the Supreme Court really fascinated by guns. Please, go ahead.
My gym has a sign outside saying you can't carry a gun at night time.
Mm-hmm.
So if someone had a gun and showed it to the front desk, does that mean that the front desk would have to allow that person to come in if they
Right, so a number of things. The question is, what about if you've got a sign, somewhere that says guns are prohibited, right? I think and your question is, what happens to the person who comes forward and says, I've got a gun and I'm coming in, right? They will probably look to this and say, well, Lopez tells me that I can come in with a gun. That, as we said before, that's a misinterpretation as I read it in the past several hours of Lopez. If you are telling people, and I've been providing specific notice, that you do not want guns in this property, someone comes forward, as I read this opinion here, you can still refuse entry. Why? Because you still do have that individual personal property right? It's still yours. And you can make decisions just as you can. It's kind of someone else has said it's the no shirt, no shoes, no service kind of a thing. Same kind of thing here, much more serious, obviously. So my own sense is, again, not providing legal advice here, as I read this, doesn't prevent a private property owner from saying, not on my property, right? It's just that this explicit way that Hawaii put this together is problematic from Alito's standpoint. Other questions? Yes, please.
This is a private property, but some schools or other things, but I'm even thinking about people like my niece who come to school for a meeting, and you have to post it up in the school board meeting or whatever. Suppose that was working out.
Right.
I mean, they're owned by a corporation, but
Sure.
that to me is private. So that confuses me.
Yeah, sure.
It also makes me go, ah.
Right. The headlines on this today are not good because, once again, it says Supreme Court upholds gun rights, take your gun onto property, right? That's not what this says, at least not the way I read it, and I'll read it again going forward here. If you've got a corporation, again, corporation owns property privately, and my view of the reading here is that if it's a school board, a hospital, those places, if you have made the decision that you do not want guns on this property, you post that, you let people know that, and because you are in control, your property interest, which is the competing issue here, tells you, I do not want guns here, you can make that decision. And so even though there would be people who would come forward to the school board meeting or the hospital and say, Lopez tells me I can bring my gun in, that's when you call a good lawyer who will tell you that restriction that you're making should be supported. Right? And so once again, it's a big issue because the Supreme Court continues to play around with this and continues the big takeaway on these cases last week and this week, just this continuing affirmation of the rights to own guns. And again, not to undermine what Antonin Scalia said back in 2008, but this real affirmation that guns are a part of our culture. And that, again, today, these are two wins, undeniably, for those people who want gun rights to be advocated for. Please.
I just wanted to make a comment and address what you were commenting on. So the gym that I go to, a gentleman would regularly came in and had his gun on his hip and his spare magazine. And I was very uncomfortable.
Yes.
about it. I asked I would not want to be part of some incident that someone's so even though we have a locked gym, I asked the manager, could she speak with him? She did. He complied, and he has discontinued wearing his gun in the gym. And no fuss, he complied readily. But now I'm wondering, should I talk to my manager again about do they want to post or just not?
Right. My view of this is they certainly can. I think what the management said there at your gym is entirely appropriate, right? A gym, a private facility, right? I assume you pay dues there, those kinds of things. They have the right to make decisions about who it is who can and cannot be on that property, including, as the manager there said, we are not permitting you to come on with a gun. I don't think there's anything about this case that prohibits her from doing that or from posting something that says just that. That fellow may well be home tonight saying, I'm reading Lopez and I can bring my gun tomorrow morning. You need to get a copy of the opinion and at least read the summary of that so that your management there knows that's not what this case says. Please.
So are you equating then private property, you mentioned
Right.
school boards,
Right.
and I'm thinking university campuses,
Right.
that kind of thing.
Sure, right, and those, right, those are public, and so the specific issue here in Hawaii is about private property. It's the gas stations, those kinds of things. The next question is, okay, you've got a governmental entity. The same should still apply, right? And that means that, again, even if it's not squarely within the scope of Lopez, you are still inviting the public in, and you still have a larger interest in ensuring the safety and security of people there. I don't see any reason why you could not impose a similar restriction in those public settings, school board meetings, governmental assemblies, those things like that. A slightly different case, but still not inconsistent with this. Please.
Many of the public buildings that I have gone into, the library, police department, county building, city building, they're posted. It's right on the door. You can't get in the building without seeing that thing on the door. It says, no firearms allowed in this building. And that would go to this ruling, because when I'm looking at it, I'm thinking, okay, you got a picture of a shell station there, and the lower one looks
Right.
like it might be.
It's a shopping mall, yeah.
If it's not posted,
Right.
the law can't require someone carrying a gun to go and say, I have a gun, get it ready.
That's exactly right.
If it is posted, then you can't bring a
Right,
gun in.
right.
So
It's, yeah.
it's pretty narrow. It's
Right.
just the fact that, well, if the owner of that property didn't post it, then you don't have to ask.
Right.
And I would think that pretty much everybody that doesn't want a lot of firearms around would just put a simple sign on
Right.
their building that says, please don't.
Not
bring any
permitted here, right?
firearms in here, or no firearms allowed.
Right. And you have articulated perfectly exactly the way this would happen. The reason why the Supreme Court didn't like that was because you're imposing upon the gun owner the obligation to ask permission. And they're basically saying that is an infringement of your Second Amendment right. If it's posted, you should follow that. But absent that request and absent some posting, then this permits you to go on to a shopping mall or other places without, you got it exactly right, yeah. Yeah. Fascinating cases, right? And again, underscoring the fact that we've got a Supreme Court that does a lot of these cases, certainly in the future. I just want to identify something that some of you may know that I'm somewhat affiliated with, a thing called the Wisconsin Anti-Violence Effort WAVE. It is a nonprofit group that advocates for, candidly, reasonable, rational conditions on gun ownership. And very proud of the fact that on the 4th of July, the Cap Times is going to be publishing an editorial, an op-ed piece, and we talk about, again, the importance of being a patriot and acknowledging our 250th anniversary, but also recognizing that we still have, we do not have complete freedom from violence in America, and that guns are a part of the violent history that we have had, and advocating life, liberty, and pursuit of happiness. Part of that has got to be these kinds of things. We will continue, as you'll see, next time talking about the Fourth Amendment. I promise we'll get to that. Some very interesting things coming out of the history and the news recently. I'll tantalize you just a little bit with some of this here. And we're going to talk about searches and seizures, and we're going to talk about the Eighth Amendment next time, and we'll talk about all of that. I wanted to identify for you, before we conclude today in the last few minutes, all the things that the Supreme Court still has on its docket as we get together here on the 25th of June. The big one, birthright citizenship, although probably not the big one. I've said this before. Almost certainly the Supreme Court is not going to give the president what he wants. This is the 14th Amendment issue, whether if you are born in this country geographically, whether you get citizenship, plain and simple, as has been the case for the past 100 or so years. President wants to change that. If you are born of a mother who is illegally here or here only temporarily, then you're not a citizen. Almost certainly they're not going to do that. Interesting to see if they issue this right on the eve of the 4th of July. Maybe that's what's happening here. Not too much of a surprise there. Transgender athletes, transgender women in women's sports, it appears that they're going to permit states to restrict the participation of transgender women, permit them to do that. I still think that aside from the voting rights case, maybe the tariffs case, The other big ones that are out there, there are two of them having to do with presidential powers. This is the question of whether or not the President of the United States of America can fire people in independent agencies. The Federal Reserve is one of them, that's Lisa Cook. And the Federal Trade Commission, that's Rebecca Slaughter. Maybe that the Supreme Court comes down in different directions on those. If they do, they've got some splaining to do and justifying their theory on that. And then going back to the things we chatted about as we began this evening, a couple of very big cases having to do with elections coming up, mail-in ballots. We talked before about this right before we went on the recording here. There are states, including Illinois, other places around the country, where if you postmark your absentee ballot by Election Day, but it's received afterwards, the state will still count that. And the question is, what is Election Day? Is that permissible? Supreme Court's going to tell us if those grace periods are possible or not. And then there's also a big campaign finance case coming out of our vice president, and the issue there is whether or not individual political parties, the Republicans, the Democrats, name your political party, can directly support campaign candidates. For the most part, it's a very complicated area of the law. This is not my area, but as you know, probably through PACs and other things, that's how they can support candidacies. Are all of those things, like other cases that they have decided, Citizens United, for example, are those restrictions on the capacity of political parties to support independent candidates financially, are those constitutional? Not a lot on their docket between now and next Thursday, and certainly the time that we get together next. I will also tell you, and we'll talk about this more, I'm going to do, as Kristen often knows, and Blue Sky often supports this very much as well, I'm going to do a couple of things in July talking about all the Supreme Court cases. We'll chat about that down the road. But note once again, we're getting together again right after the 4th of July on the 9th and the 20th, August 6th and 13th. And I promise we're going to get through the other amendments, and then we're going to talk a lot about the relationship between states and the federal government. We're going to talk about the media, what lawyers do, and specifically what legislative representatives do, what their role is. Got a lot of things to cover, but we've got 4 more classes yet, so plenty of time to do all of that. And for tonight, in any event, I thank you very much once again for being a part of this, and we'll look forward to having you here once again and doing more of this discussion in just a few days. Have a good night, everybody.
Before we end the recording, I was hoping to seek a point of clarification
Yes.
on the 2025 case in relation to religious freedoms and public education. Would it be possible to go back to that slide?
Yes, absolutely. Yep. Let's do this. You're talking about the it's not this one. You're not talking about the religion. You're not religious.
I'm talking about the one I believe right before this.
Okay.
Not with the same slide as the football, that last bullet
Right,
point
right,
there.
yep,
I
right.
just had a clarifying question to make sure I and anyone watching this on YouTube later understand what that case is.
Right. It's called Mahmoud is the name of the case. Mahmoud, right?
Okay, so my question is, SCOTUS found that a free public education cannot be conditioned on the parents' acceptance of instruction that poses a real threat of undermining religious beliefs.
Right.
Does that mean, am I correct in believing that means SCOTUS found you do not, in a public school, your curriculum does not need to care if the facts contradict a person's religion? Is that what that means?
I may not describe it quite that way. I would say that if I have, for example, here's the way I've described this in the past. Let us suppose I'm a part of a religion that says that the earth and all of us, it's all 6,000 years old, okay? And so in the instruction, the anthropology discussion at school, they're teaching a thing called evolution, and that the world is billions of years old, and we are the products of all of that. My faith tells me that that's wrong, and so I don't want my son or daughter to be exposed to that because it's inconsistent with my faith. What the Supreme Court has said is that if that's a part of the curriculum, you're teaching, again, fill in your science-related predicate, you can remove your son or daughter from that education piece, that curriculum item, and you've got a constitutional right by virtue of your right to express your faith as you like to do just that. Does that make some sense? Does that clarify something?
So I was confused by the wording of cannot be conditioned on the parent's acceptance of instruction. So
Right.
based on what you
Right.
said, am I correct in understanding? I believe in Wisconsin we hear a lot of times about. I think this was a big case in Watertown, where if there's a controversial issue, you must share that with families and give them the option to pull their students out of that class.
Right.
Is that allowed because of this Supreme Court decision?
If it depends upon, it certainly is sanctioned now. This was just last year. So, and the language you're focusing on there is, so, and it focuses on the principal notion here. If you are in public education, your right to public education is not conditioned upon your agreeing to a particular curriculum. In other words, so I can in fact withdraw my student from that if I don't believe that curriculum is consistent with my faith. It's basically an answer to the question, why don't you simply then go to a private school? The answer is you can't condition public education, according to the Supreme Court, on your accepting the curriculum as it is. Does that make, and maybe it's a kind of a cumbersome way of describing it. Yeah, good. And again, that language is sort of pulled from the Supreme Court case itself. Plainly, there's a whole lot more going on there. But again, it's a real affirmation of the freedom of exercise of religion inside a public setting, and the confluence of those things in 2025 and 2026. Good. Great point, Jacob. Good. I'm going to stick around here for a while. We have more questions, but thank you all again for being a part of this, and we'll see you on the 9th, if not before. Have a good 4th of July, right? Everybody, take care.